Hi, my name is Shohini Bagchee, and I'm a senior patent agent at Field Law. In today's episode of IP Explained, we're going to talk about patents. It's all in the timing. An important question in looking at patent protection for your invention is when should you file for patent protection? The most important rule to remember is that you need to file before any disclosure of your technology. Disclosure of your invention before filing for patent protection can become a bar to patentability in many countries around the world. The second important thing to remember is the patent system works on a first-to-file basis, meaning the first inventor to file for patent protection receives the patent. So a good rule of thumb is to file for patent protection as soon as you feel your technology has been finalized. In case there has been disclosure of your invention and you have not filed for patent protection in at least one country, there is still options available to you. Many countries around the world recognize a grace period of anywhere from 6 to 12 months from the time in which you disclosed your invention. In Canada and the US, you have a full year of grace period in which you can file for patent protection after you've disclosed your invention. We always recommend discussing this situation with the patent agent to determine the best course of action in case an invention has been disclosed before you file for patent protection. Once your application is filed, there are a number of options for either slowing down the prosecution of your patent application till it's granted or speeding it up. Some of the reasons you may wish to slow down prosecution includes deferring the costs of examination and prosecution, or raising funds for your patent protection strategy, ensuring that there's a good market for the technology that you're patenting, and perhaps seeking investment into your technology. The main reason for speeding up patent prosecution of your invention is if you think that there may be infringement by a competitor of your technology. Only a granted patent can be enforced against potentially infringing activity, and in that case, you may wish to get a granted patent as soon as possible. Once you've determined if you want to speed up or slow down prosecution, there are a number of options by which we can do so. Some of the options to slow down patent prosecution include filing a first informal patent application, which then gives you 12 months from filing to determine what other countries you wish to file for formal patent applications. Another option is to defer examination costs in any of the countries in which examination deferral is an option. And finally, you may wish to choose to file via the Patent Cooperation Treaty route, or PCT route, as a way to buy a little bit more time and defer decisions on what countries you wish to file in. In terms of options for speeding up patent prosecution, a number of countries offer accelerated examination at additional examination fees. Canada and the US both have this option. As well, we can take advantage of bilateral agreements between patent countries across the world called the Patent Prosecution Highway, or PPH. In the PPH system, if you have an allowed application in one jurisdiction, you can use that allowed application to expedite examination in another PPH member country. In Canada, using the PPH route can speed up examination by up to a year. If you have more questions about patent timing, when to file, and how to speed up or slow down your patent prosecution process, please feel free to be in touch with any of the patent agents at Field Law, and we'd be happy to help.